No rule that touches 50,000 lives should pass without a nation asking why. In a quiet notice from the Office of Personnel Management, a rule was set to take effect on March 8th, one that could make tens of thousands of career officers serve at the pleasure of the President alone. They call them policy-influencing posts, placed under a new heading named Schedule Policy, Our Career. Yet the change revives an old spirit once known as Schedule F, a spirit the country once swore we had buried. Picture the doors of OPM on E Street in Washington, the seal of the eagle catching pale morning light as staff file the final pages for release. Inside those pages lies the authority to dismiss civil servants without appeal, without protection from the Merit Systems Protection Board, and without the outside ear of the Office of Special Counsel. 50,000 duties, scientists, analysts, economists, clerks, rest on that paper. What the pen grants, the pen may also take away. Officials say the purpose is accountability. Critics call it politicization. Can both be true at once? The director declares that he seeks a more responsive government, denying any purpose of partisanship. Yet unions like the American Federation of Government Employees voice alarm, arguing it reopens the spoils gate the Pendleton Act once closed. Imagine the Federation's headquarters on New Jersey Avenue, clerks stacking case folders beside the words, "Court challenge imminent." Across town, at the Department of Justice, attorneys prepare their own arguments that the President must direct those who carry out his will. Between those files stands the Constitution itself. How can law serve both speed and justice? A republic must move, yet remain upright. The founders gave a president wielding energy, but fenced by law. Congress, speaking later through Title V of the United States Code, sought to preserve the merit system that keeps the public service impartial. The test before us is not efficiency, but equilibrium. Picture a conference room at the Merit Systems Protection Board, empty chairs holding the silence of uncertain future cases. If those who complain of misconduct must now plead to the very agency they accuse, the hearing becomes confession without judge. Still, the advocates of the new system answer that delay and red tape have crippled honest management. They ask, why should presidents bear responsibility for failure they cannot remove? Wasn't reform meant to end this forever? In 1881, President Garfield was killed by a defeated office seeker crying about patronage. Out of that blood came the Pendleton Civil Service Act of 1883, establishing merit above favor. The nation chose then that competence, not campaign, should open the door to service. The spoils system died hard, yet its ghost forever shakes the latch. Each generation faces the same temptation, to let loyalty count for virtue and obedience for skill. Think of the marble facade of the old Pendleton post office in Cincinnati, where the idea of reform first caught wind. The stones still bear the marks of letters carved by men who believed honesty could be built in law. When a worker's livelihood depends on favor, truth withers, and silence blooms. The Republic suffers not by loud treachery, but by whispered caution. Who guards the guardians when loyalty is the test? The administration says internal counsel will investigate wrongdoing. Yet investigation without independence is like a jury drawn from the accused. Our nation drew strength from officers who would tell hard truths. It draws weakness if candor costs them bread. In the days of President Andrew Jackson, patronage was called rotation in office. Giving every friend a turn. It sounded democratic. It proved disastrous. A government run by favors cannot promise justice to those outside its circle. The Pendleton reformers learned that lesson in toil. We risk learning it again through loss. Picture the steps of a federal courthouse in Minneapolis, lawyers carrying the names of those soon to lose protection. A small motion of paper that might decide whether future servants speak freely or hold their peace. Some say modernization demands flexibility. Indeed, the president must have power to act when performance fails. But liberty requires restraint, even when restraint is inconvenient. A line exists between command and domination. The Constitution drew it in ink that has not yet faded. It grants the president execution of the laws, yet assigns Congress to shape the framework of public employment. To cross that line is not reform, it is absorption. the slow swallowing of all independent will into a single throat of power. Picture a young attorney at the Department of Interior reading the new rule, wondering if the next memo will decide her fate. She entered service not to serve a movement, but a nation. Her conscience, not her party, is her badge. Such citizens are not obstacles to policy. They are its trustees. A strong president should cherish them as ballast, not treat them as ballast to be thrown overboard. Our forefathers did not see government as a family business. They wrote a charter to outlast the tempers of men. They understood that liberty stands only where power checks power. The president executes the law, yes, but he does not own it. The Congress enacts it, but it must also abide by it. Between them lives a body of public servants who keep the wheels turning when elections end. They are linchpins between election and endurance. And without them, freedom swings loose. Picture the reading room of the National Archives, the yellowed copies of the first civil service registers lying open. Next to each name, once carefully typed, is a note of merit earned by exam, not friendship. Those records tell how a country tried to turn virtue into procedure so that morality would not depend on the next man's promise. Reform was a bet that law could protect character. It was a good bet then. It remains one now. Those who favor the new system will answer that trust in the president is trust in the people who chose him. They will say that an unelected clerk should not block the people's will. There is truth in that argument, but only half of it. For the people who choose a president also choose a Congress, and they have placed both under a constitution that divides their reach. What begins as faster government can end as master government. Think back to the small telegraph office once attached to the Pendleton Post building. In 1883, a clerk there sent the wires announcing the signing of the Reform Act. Every fair-minded worker for the next century would owe him quiet thanks. His message declared that America had learned self-control. We must decide if we have forgotten the lesson. I have seen how nations lose themselves when rulers seek perfect obedience. It does not happen with gunfire. It happens with new forms, new titles, new schedules. Each seems harmless until all combine to make loyalty the only qualification. Picture the Supreme Court building at dusk, its white columns reflecting a gathering storm cloud. Inside its chambers rests the power to say whether law or order takes precedence. When judges read the text of Title V, they will not only measure statutes, they will measure the nation's patience with unbounded command. Law alone will not guard the chambers of liberty. Habit must guard them too. Citizens must revive the habit of caring how their government works, not only what it promises. A people inattentive to process soon loses substance. Picture a town square in Des Moines as neighbors talk about lost manufacturing jobs, taxes, schools, ordinary worries that depend on unseen offices staying faithful. That unseen hand pays every teacher, inspects every bridge, delivers every letter. When that hand trembles from fear of dismissal, every other task weakens. So the question returns, plain and personal. What kind of service should a free people demand? Not blind loyalty, nor absolute independence, but honest duty under law. Government works best when conscience, not favor, decides each day's labor. Picture the marble lobby of the Department of Labor itself, the old mural of men and women holding tools and ledgers. Their eyes look outward, not upward. To those in offices today, remember that silence is not safety. To leaders, recall that obedience bought too cheaply will fail you when truth is needed most. To the citizen listening now, hold your standard firm. Ask not how to punish one party or another, but how to preserve justice for all to come. The dangers before us are real. The remedies are still within reach. Every generation must decide anew whether law shall master power or power shall master law. Only one of those choices keeps the promise of 1776 alive. The nation has faced such moments before and endured because somewhere a conscience refused to bow. Let that conscience live again. Let honest work stand above party line. The Republic can be saved. When that test reaches your own door, will you still choose what is right over what is easy?